All right, we are live. Thank you everyone for joining me on a Q&A regarding divorce, custody, parenting time, and all things family law related. I appreciate you signing up and joining us today, giving yourselves an opportunity to get educated and understand the process with regard to divorce, custody, parenting time, and almost any other family law issue that you might want to talk about. That's why I'm here, to answer your questions so that you can move forward in the best way possible with the most knowledge that you can possibly have. Just briefly who I am. Actually, before I get to that, I just want to let everyone know who's here that this is a safe place. All right. I'm not using names. I'm not using anything that would identify anybody. When you send your message through the chat, or if you send it to me by email, I'm not going to give any identifying information. And if there's any particular information that might be able to identify you, if it's really, really specific, even though it's just a factual detail, I'm not going to share that information because everything that we do here is confidential, which is exactly the same as if we were meeting in my office or we're on a phone call, and the same for any texts or emails. Everything is confidential. I consider this to be attorney-client privilege. Strictly speaking, it's not what it is here for a webinar, but I'm not going to use your information. So feel free to ask whatever question that you want to ask, and I won't use your personal information. Just some background information ever so briefly for me. I'm Garry Greenberg. I am the owner and founder of the Smart Law Group. I am the lead litigation trial attorney for the Smart Law Group. And I've been doing this for 40 years. And I started off at the very beginning practicing family law, doing divorces, handling custody matters, parenting time matters, support matters. So I've got a few years under my belt, and it's given me a lot of opportunity to gain a lot of experience that I can share with my clients as they move forward in the best manner that they can. So I just wanted to give you a little bit of background for myself so you know where you're getting your information from today. So I'm just going to kind of jump right in because this is a Q&A session, and I'm looking at some questions. See, we've got a lot of people here today. My experience is a lot of questions will overlap, and I even got a few questions in advance because some people wanted to email those to me before they joined us today, probably so they could get their questions heard first. The first one, and this is a very, very common question, is how long does it take to get divorced? And my first answer is it all depends. But the technical answer is any lawsuit in the state of Michigan takes a minimum of 60 days from the date that the case was filed, excuse me, until the judge can give a final judgment of divorce. So if you walked into my office with everything agreed upon, we could time everything so that we could be done in 60 days, 61 days, 62 days, depending on the judge's schedule. Now, if there are minor children involved in your case, the minimum amount of time, there's a statutory waiting period. That statutory waiting period is a 6-month period of time. And the concept behind it is to give mothers and fathers an opportunity to acclimate themselves and their family to the divorce process and help the children through that process also. They don't want to just jump into something a couple months later where the case is completed and nobody really knows what they're doing. They're just trying to maintain a little bit of the status quo and stability. And I think that rule, that statutory waiting period, comes from a long, long time ago when the public policy was, you know what, let's give everyone a chance to cool off and think about their case and figure out how they're going to move forward, as opposed to just automatically divorcing them and just creating a mess for the family. I think that's the background. However, having said that about that 6-month waiting period, most judges in our area, and most judges in Michigan, although there's a lot that don't, will waive that 6-month waiting period. But when you get into a divorce case, you have to expect that there will be a minimum 6-month period of time before you can actually get divorced. The final component to this, for how long it'll take, the Michigan Supreme Court has a report card for all the judges in the state of Michigan. And the Michigan Supreme Court has told all of the judges that handle divorce cases that we want all the cases done within 12 months. So most of the judges, when a case comes in front of them, no matter what the issues are, they want to get that done within a 12-month period because they want to get the best grade they can with the Michigan Supreme Court. So that's something else to consider. Sometimes you hear horror stories about cases going on for years and years. That really doesn't happen anymore. That used to a long time ago, and there are exceptions to this rule. I personally had a case that went on for about 2 years from a few years ago. It was right after COVID started. And there were a lot of extenuating circumstances. It was very difficult to get trial dates and get into court to do what you needed to do. So it took an extended period of time. Sometimes cases will be extended a little bit because there's business valuations. Sometimes there's particular issues with the minor children that need to be sorted out. And so judges will violate that. It's not breaking the law, but they'll violate that 12-month period of time because they want to do what's best for the family. So those are the basic cutoffs that you have, that 60-day period, the statutory 6-month waiting period, and then the outside limit of 12 months. Now, all that having been said, that's really what the law and the court rules call for. As a practical matter, if you don't have minor children, it's very typical for a case to take about 4 to 6 months from the day the case gets filed. If there's particular issues, you're probably looking at 6 to 8 months. If there's minor children, it's about the same period of time. Again, a lot depends on how much each spouse can cooperate. Does the husband want to cooperate with the wife and vice versa? If there's children, do the mother and the father agree on a parenting time schedule and the custodial arrangements? So those are all things to take in mind, to keep in mind when you're trying to consider how long it takes to get divorced. So let's go to our next question. How do I get a no contest divorce? In my world, describing or saying something is a no contest divorce can mean a number of things. And I know that even when people call me to ask that question, I have to ask them exactly what they are talking about. Now, the easiest way to describe a no contest divorce is when the other side doesn't contest it. They don't hire a lawyer. They just the person who calls me, the person who wants to file the case, just wants to file the case and move forward. Now, even if it's a no contest case, the other spouse still has to be served with the paperwork. And unless you have an agreement in advance, you never know whether they're going to contest it. Are they going to say that they want something out of the house? If there's children, is there an agreement on the parenting time and the custody? All kinds of issues can come up. The most typical no contest divorce is someone who might have been only married for 6 months or even a year, 2 years. They haven't accumulated any property. They may have already separated. So the way that you get a no contest divorce is you start by seeing a lawyer, providing the information that you need to provide, and the paperwork gets filed and the other spouse gets served with the paperwork. And then you really have to wait to see what they're going to do. A true no contest is when the husband and the wife have already talked about many of the issues and there's absolutely nothing that either side wants to fight about. And that's always a good thing. Even if they have assets and property, you can have a no contest divorce if people have been married for 5, 10, 20 years, even more, if they've agreed on everything in advance. And that'll move the process along a lot more quickly. It'll also probably be less expensive, but those are some of the considerations when you're thinking about a no contest divorce. And just one other thing I want to point out with a no contest divorce, just because you might want it to be no contest doesn't mean that the other side doesn't. So those are all things to be discussed at the very beginning of a case when it gets filed, so that we have an idea of what the plan is going to be and where we want to end up. Let's see, another question. We have a question regarding ownership of a business. Now, every situation is a little bit different. And this question relates to a husband owning a business. Now, the first thing that I want to say is, if that business was created during the marriage, that is a marital asset. That marital asset needs to be divided between the husband and the wife in the divorce. And depending on the nature of the business, it depends on how big it is. It depends on how much money it generates. There's different ways to value a business. And the question actually has to do with, does the wife have to walk away from the business? Well, I'm going to give you the lawyer answer. The lawyer answer depends on all of the details. And this is the kind of question that I would want to have a one-to-one conversation with that person. Again, we come back to it's the fact that the business is a marital asset. And so how does that get divided? If both parties, the husband and the wife, were working in the business, even if one wasn't being officially paid, they are still contributing a lot to the existence of that business. And so, how big is that business? How much was the one spouse giving up by working for free? Did the other spouse buy a house and buy a boat and buy all the cars and things like that? Those are all marital assets. Those still need to be divided. And again, depending on what the income is from that business, that's something that is also going to be considered in dividing what is going to happen. The duration of the marriage is another variable to be considered in that process. So to specifically answer the question that was being posed is, is the person who gave us that question just have to walk away from it? My answer is no, absolutely not. But it depends on a lot of variables. I'm going to give you a real simple hypothetical because it's not so much a hypothetical. I had this years ago where the husband owned a landscaping business. He cut grass. He had a pickup truck, he had a trailer, and he had a lawnmower. And the wife helped do the books. Well, that company did not generate a lot of business or did not generate a lot of income. So there wasn't a lot to divide. Basically, what they did was they shared in one revenue generating job, basically. Now, I also years ago had a similar business that was a landscaping business where the spouse, the wife, worked in the business, and they had 3 teams of trucks. They had about a dozen employees. They were generating a lot of money, and there was no income specifically to the wife, but we were able to identify what that income would have been, what her value to the company was. So that gave us an opportunity to make sure that my client, which was the wife in that case, was fully protected and didn't lose any rights in that business. So I appreciate that question. And I see there's a couple other details. And the fact that, it's been owned for a long time, there still is an ownership interest in that business. As far as I am concerned, the added detail is that the business was owned for 25 years. Well, did that business grow during the marriage? The marriage wasn't as long as 25 years, but there still was a contribution from the wife to increase the value as I see it without having more details. So again, I appreciate that. I will point out that when there is a business involved, it just takes a very careful inspection of all of the details. It is not something that anybody should ever just walk away from. The classic thing that I hear from potential clients and clients is, well, my husband said he owned it way before we got married. I'm not entitled to anything. Don't let him throw that falsehood on you. All right. It needs to be looked at, again, in the context of all the details that existed 25 years ago when you got married and what is going on right now. It is not something that you should be walking away from. It is something that you should explore in far more detail. So I appreciate that question. Next question. Actually, it's kind of related to that last question, but it was pretty broad question being asked. How do I protect myself? There's lots of ways, and I'm not sure exactly what the person was referring to when they talk about protecting themselves. But I think the most important thing to do in protecting yourself is to know what assets that you have in the marriage and what debt that you have in the marriage. You should be aware of everything. And if you can get documentation, all the better. It always scares me just a little bit, and it creates more work for me, which is what I do. And I'll find it when a spouse comes to me and says, my husband or my wife handles everything. They don't let me touch any of the accounts. They don't let me pay any of the bills, and they sign for everything and take care of everything. Well, we have to go back and find out what is going on in that marriage. Where is the money going? Money's coming in and money's going out. Where is it going out? So the way you protect yourself is by educating yourself about the family finances. Is there, where are the bank accounts, credit union accounts, investment accounts, retirement accounts? A lot of people are just totally unaware of what retirement accounts that their spouse has. Now, having said that, just don't one day have your spouse come home and say, I want to see all this information. That can create a very awkward situation. To the extent you can, my recommendation is always see what you can find out on your own. Look at the mail, look at tax returns. Tax returns are very important and can reveal a lot of information. You want to look at, certain personal documents that will give you clues as to what's going on. Look at credit card statements. Look at those bank statements. See where the money is going. There's an old adage about, follow the money. That's going to answer a lot of your questions. And that having been said, if you can locate those documents, if you can identify those documents, I always say make a copy of them, because once you file for divorce, those documents may disappear and it'll be more difficult to get to those documents. It's also important to know what are all the passwords to the various accounts. Now, again, some spouses don't want to share that information, and that can be a problem. You never want to have a confrontation with your spouse, but if they're not willing to share the information with you, personally, my experience tells me there's a problem. I don't want to say that they're doing anything wrong, but there's still a problem. All right. You're not in a partnership anymore. You're in a kingdom, and your spouse is wanting to act like a king and control everything that is going on in the marital home with regard to the finances. I think it's very important for a husband and a wife to share control. Otherwise you don't know what's going to happen with assets and liabilities. You don't want someone spending all the money and all of a sudden it's gone and nothing's left, and you never had an opportunity to protect yourself. Someone asked about crypto. If you can find out about crypto, you definitely want to grab whatever information you can. Very often I learn about crypto related accounts by looking at bank statements, credit union accounts, and credit card statements. You can identify Venmo transfers, Cash App transfers, PayPal transfers. I had a case where I was able to identify transfers from the bank account to a Bitcoin account. And there's all kinds of crypto money that's out there under different names, and there's different ways that people can do that. But again, what you want to do is follow the money. And that's part of what happens when I get involved is I need the financial documents so I can help my clients follow it, because most of my clients don't really understand what to look for. And the other thing, just a couple other points about protecting yourself. And again, I'm just throwing these out there, and every case is different. So I can't say if it applies to your situation. I think it's always a good thing for both spouses to be on a bank account, or for my client to have their own bank account. All right. So they don't have to worry about what is going in or out. Once something goes into it, it's going to stay there and they can control it. So I like the idea of having a separate bank account so that the other party can't get into that money. Also, be very careful about your mobile phones, because whoever is the administrator on that account is able to go into that mobile phone account, even though it's your phone and your phone number and the one that you used for many years. If you share a phone account, you can go into, and you're the administrator, you can go in and see who is sending texts and receiving texts. You can see where the calls are going and where the calls are coming from. And, you want to protect yourself. You don't want the other side to necessarily know exactly what you're doing, especially if you're contemplating a divorce. You don't want them knowing that you're talking to, your family, because it might look unusual. You don't want them to know that you're talking to your lawyer, before you've actually filed a case. It's a possibility that could happen. The bottom line is, if you are thinking or worried about protecting yourself, it's probably time to have a very in-depth conversation with a lawyer to be able to identify what you need to do specifically to protect yourself. And forgive me for rambling, but also a way to protect yourself is, when a case is filed, if you're worried about money that's going in or out of the marital estate without you knowing what's going on, one of the first things we would ask for is an asset injunction. They actually are usually mutual, and that stops either side from changing beneficiaries, selling property, taking out loans, things like that. You can still do your day-to-day regular business banking and buying and selling, what you need for the home, but there's not going to be any large purchases, and that will stop that dead in the tracks. So that's pretty much what I have to say about protecting yourself in a divorce. I see another question, which is a great question. How do I know what the custody is going to be? And when you start a divorce case, it's always impossible to know. And if you have conflicts between a mother and a father, it's even more unknown. You don't know what the mother's reaction or the father's reaction is going to be to a divorce filing. But by filing the divorce, one of the first things that will happen is a very close review of what is going on with regard to the children. And one of the best ways to know what might happen in the future is what has happened in the past. If one parent was taking care of the child for most of the time, it was a primary caretaker, there's a better than even chance that they're going to continue being that primary caretaker. If one parent was always traveling, was never around, would spend weekends away, that's not going to look good for that parent. And, they're going to be less likely to be able to make a solid claim with regard to custody. And when I talk about custody, that also applies to parenting time. You have to take a look at what are all the circumstances in your situation. Do both parents work? What are their hours? How old are the children? What grade are they in? What are their extracurricular activities? Do they have any special needs? Those are all things that get taken into account. Every case is different. And that's why we need to sit down and go through each and every detail regarding your situation to determine what is in the best interest of the child or the children. And that's one of the things that the court has to look at. If the mother and father can't agree, the court is going to determine what is in the best interest of the minor children. There's 12 factors that they look at, and we go through them. The judge goes through them one by one. And every case that I've ever been involved in, I go through them with my client because we want to get a good idea of where do we stand? And based on my 40 years of experience, what do I know that judges are looking for based on the facts that you have in your particular case? And there could be a whole bunch of things that are very good, and I can give you a better assessment. This is where I think we're going. And then you can tell me, well, this is what father wants, and this is what father is saying. And I can tell you, well, that really doesn't fit into the best interest factors very well. So we can get a pretty good idea of what is going on. In a perfect world, if the parents can communicate, and it happens a lot, it's not like everybody is always fighting about the custody of the kids. If they can reach an agreement, it's always going to be better for the children. And whatever agreement that you reach, as long as the two of you agree on it, 100%, the court is going to agree to that also. So hopefully that answers your question regarding what custody may or may not be. Let's see. We have a question about private school, and that can be an issue. And frankly, I'm involved in a number of cases right now that involve the choice between private schools, parochial school, and public school. And again, every case is going to be different. It depends on what are the ages. It depends on where they're going to school. It depends on what has the history been in the past. It depends on whether there's any particular needs for the child. If there's a divorce, it depends on where the parents are living. That can be a factor also. There's way too many factors for me to tell you that this is what would or would not happen in a particular circumstance. What I tell my clients when they come to me with those kinds of issues, again, we need to go through all the factors that are related to the best interest, take a look at what the other issues are with regard to choosing one school over the other, and then we make our best arguments for what should or should not happen. And in many instances, sometimes it does require a change in circumstances, again, depending on the divorce, depending on the parents, depending on the assets that are available. So sorry, I can't be more direct on that question, but it certainly is something that is worth looking at. And I'm always happy to have a more direct conversation with anyone that wants to contact my office on something like that. I see a question regarding parental alienation, and that's always difficult. It's difficult for attorneys. It's difficult for judges, and obviously it's difficult for the parent who's being alienated. And one of the most important things to do in a case where there is alienation, in my opinion, how I approach it, is setting boundaries. And I understand that a lot of people, a lot of parents that are suffering from some form of parental alienation, it's really hard for them to communicate with the other side because that parent is not cooperating with them. You want to make sure that you continue to do the best things for your child as long as you can, as much as you can, even if you think they're acting negatively towards you. My experience has been, as long as you continue to do the right thing with your children and you try as best you can to be fair and honest with the other parent, that will weigh in your favor as we go through the process. When many times when people come to me with situations of parental alienation, it's been going on for a very long time. And it's not as easy as just changing it with a snap of fingers in front of a judge. However, if that is going on, depending on exactly what is or isn't going on, one of the things that I recommend that my client does with my help is we go to court immediately to set those boundaries as clearly as we can as to what the parenting time is going to be, what the custodial arrangements are going to be, what their involvement is going to be with the children, and make sure that they have every opportunity to engage with those children as a parent, as they are entitled to do. And Michigan law is very clear that there's several different areas where Michigan law is very clear about wanting to establish the parental relationship and make sure that it is a solid relationship with each parent. And sometimes when parental alienation is involved, it requires therapy, and whether it be for the kids, It could be for one parent or both parents. Sometimes it's therapy that involves the child and the parent to be able to get over some of the hurdles that are there. Sometimes it requires what's called a forensic evaluation to determine what exactly is going on in that parental relationship. So there's a lot of factors that need to be considered. And it is my humble opinion that they require action, because the longer that alienation goes on, the more difficult it's going to be to undo it. I think it is undoable, but it can be very, very difficult. And it requires, I'm a little bit leery about using this word, but to be aggressive about stopping it. Not that I have any problem about being aggressive with the other parent. The bottom line is we want to make sure that we are doing what's best for the children, but we also want to present the best case we can for the judge. We have to keep that in mind. Just because something feels good, because you can stick it to the other parent because they're doing something wrong, we want to make sure that that doesn't backfire. So be very, very careful about trying to take things into your own hands when you have an alienation situation going on. Let's see, I have a question. Does where we got married matter? No, it doesn't. I have clients, in fact, I had someone just last week, they were asking about, well, we both got married in North Carolina, and can we get divorced in Michigan? It's like, well, of course you can. And I know they don't know, and I appreciate that they called me to ask the question, but it doesn't matter where you were married. Even if you're married outside of the United States, if you were legally married in the place where you got married, you are legally married in the state of Michigan. So that's not a concern at all. And it doesn't matter where the children were born either. If everyone is in Michigan, it is a Michigan divorce case. Let's see. Sorry, I kind of like this question. I've heard Oakland County is a nightmare for divorces. I don't really agree with that. I think that if you prepare and plan appropriately and you execute your plan in front of, with the other side and in front of the friend of the court and or the judge, that it will go in the direction that it needs to go. Unfortunately, with divorces, there's nothing happy about divorces or necessarily anything easy about divorces. And, there are some judges that in every county are going to be more difficult than others, but the bottom line is you can't worry about what everybody else is doing. What you have to do is figure out where are we starting and where do we want to end up? And what's our plan to get there? I think that avoids a lot of nightmares. I think nightmares happen when people are trying to do things, or attorneys are trying to do things that aren't logical or don't make common sense, or try to overreach. And unfortunately, in this business of divorce, attorneys can fight about a lot of things that shouldn't be fought about, but they have, unfortunately, a client that may be able to afford that fight, and that just prolongs things. It makes things more difficult. So I like to be able to step back from that. They can do whatever they think they need to do, but we're going to execute our plan. That's the bottom line. We're going to understand what the facts are, what the circumstances are, what the law is, and we are going to move forward. We don't have to keep worrying about what they're doing. We'll have to address it. We may have to defend against it. We may even have to get aggressive and get offensive with regard to what's going on by the other side. But we need to execute our plan. That's what's most important in any divorce case. And I think that's what avoids having nightmares. Let's see. Wow, lots of questions. I appreciate this. The age of the child doesn't matter. That's a real common question. In the best interest factors, one of them is the reasonable preference of the minor child if they're of an age to express that preference. That's only one of 12 factors. Usually, the child has to be at least 12 years old, although in every custody case where a judge has to determine custody, the judge is going to interview the children. But that interview with the children is not like, where do you want to go? Where do you want to live? Who do you like better? Who's mean to you? It's really just to try to get a feel for what that child's life is like. And you can get a pretty good idea if you have a relatively normal conversation with a child about, what they think about their lives with both parents and their relationships with both parents. The older they are, the more likely they're going to have a little bit more say-so. I would say, someone that's under 10 is not really going to have any say-so about where they live at all. Very seldom will you see that happen. If a child's 15, 16, 17, they're going to have a lot of say-so about where they're going to live and where they're going to stay. They may have their own vehicle, so they can drive to their friend's house. And they had a case where neither parent really had custody because they were staying at their best friend's house because that's their safe zone. So, sometimes it matters. Sometimes the age of the child matters, and sometimes it doesn't. Let's see. Evading service. That's an interesting question. And that goes back to the no contest situation, in my opinion. If you want to get a divorce, you will get divorced in the state of Michigan. It doesn't matter where your spouse lives. Now, there are certain rules that need to be followed to give them as much, they're entitled to get legal notice of the divorce case. And so I have to do everything consistent with Michigan law and the Michigan court rules to make sure that I've done everything I can to give the paperwork to that other person. And sometimes you can't. Sometimes, they will evade service. Sometimes they are hiding at a friend's house. Even if they're in the state of Michigan, that can happen. There are certain rules that allow for what's called alternate service. And every case is different, and every judge has particular things that they like to see. You wind up doing internet searches. You wind up doing, you look for them on social media to see if you can locate them there to be able to give them notice, even though you're not physically handing them the paper. So there's ways to deal with that. As an attorney, I'm not much worried about if they're evading service, but we do have to make every reasonable attempt to get them served. Let's see, a couple more questions. Actually, we're going to run out of time because we're going to go to 12:45. Let me check out some of these other questions. There was another one regarding alienation. Well, that's a little bit too detailed. Well, yeah, I think the question was, what is a forensic examination? Basically, that's a psychological study that is done on parents and the children. And when I say that, there's certain testing that will take place. And depending on who your evaluator is, sometimes they will make a child support recommendation, or they're there, not child support, I'm sorry. They'll make a child custody and parenting time recommendation based on all the things that they see and all the dynamics that they see between the parents and the children. But you don't get that unless you actually go to court to say, hey, we've got a case of parental alienation and we need to have an evaluation. And here's the people that we think should do it. Or we ask the court to find one to do it. You can do it through the friend of the court, but they're really backed up and that can be difficult. And any more details about that situation is something that it's best to talk about those details with your attorney, or, that's my call to action where you can contact my office and we can talk about it in a little bit more detail. A question about retainer, really good questions here. Can I pull the retainer from a joint bank account? Absolutely. A joint bank account belongs to both of you. In theory, at least, whatever's in that account, all of it is your spouse's, all of it is yours. Now, one person can't just pull everything out and make it disappear. Each side is going to be held accountable for where the money goes. And this gets back to following the money. But the retainer can absolutely be pulled from a joint account. My only concern about that is, and I tell this to people all the time when they say, I don't have the money. My spouse, my husband typically is the one who works and I'm on the joint account, but I don't have the money for this. I don't usually like them to know, because they might know the very next day that money's been taken out of the account, and then they want to know, where is it going? And the bank account may show that it's come to my office. And so they're going to run to the attorney. So before anybody ever does that, I always want to discuss that in a little more detail to see if there's a way to make that transfer without the husband knowing. Is there a credit card? Can they borrow the money from a friend or a family member, knowing that the money's there? And I also want to point this out, that in many, many cases where one person is working and the other person isn't, and I don't know if this is the situation for the person who just asked that question, but we would ask for attorney fees at the very beginning. And sometimes you want to get, and I'll almost always ask for attorney fees in any divorce case, just to make sure that we preserve the right to get them. But there are many instances where the other spouse makes a whole lot of money and the other one does not. Well, one of the first things we're doing is asking for attorney fees to make sure that my client or you can afford to protect yourself and hire an attorney. And most judges are going to allow that in most circumstances. So yeah, in the follow-up was a credit card. Yeah, I absolutely can use a credit card. The only extra point I'll add to that is figure out what, sometimes we want to figure out when is the end period for that credit card. Is it, we don't want to have, like, if someone was hiring me today and the account closes the following day, well, let's wait 2 days before we put it on the credit card. That way the spouse won't find out about it for another 30 days. We just want to be careful with those issues. And that's something that I do talk about with all my clients. So I think we've got time for one last question. I apologize if I didn't get to everybody or I could not answer them as completely as possible. When you got the text from me, you were absolutely welcome to text me again with that question. You're welcome to call me with that question. And I'm happy to go into more detail with you. One of the things that I try to do, but you know what, we really don't have enough time to do it today, and I apologize, is to put up a screen that would allow you to go to my website, that would allow you to schedule a call, because I'm happy to do that also, and that makes sure that I'm available and that we have time to talk about your specific situation. So I apologize if I have not answered all your questions. I appreciate everyone being active in asking questions and joining me today. It's a great step to understanding your situation. It's a great step to creating a better future for yourself. And if you have children, creating that better future for your children. It comes out, I think, of a Spider-Man movie, and maybe it came from somewhere before that. With great power comes great responsibility. I think with knowledge comes power to make positive changes in your life. That's why I do what I do. And again, if you have questions, please reach out to me. I'm available by call, email, text. I'm always available. So my last request that I always make of people, I did it in the last webinar, is just make smart choices for your better future. All right. I just want you to think about what you're doing so you move forward in the best way possible. Have a great day. I want to thank you again for being here. And I am here for you, whether it's later today, tomorrow, next week, next month, even next year. Thanks, everyone.